Okay, well, good afternoon, everybody. Good to see you, except I can't see you. And, well, Happy New Year belatedly. Well, here we are, coming virtually. Isn't it nice? So you're nice and comfy at home, and I'm actually in the classroom. Yeah, can do it at home, but they keep changing the Adobe Connect system. This is the original way they were doing it. So we shall be reviewing classification of terms first, and then we shall be getting on to exemption clauses. Exemption clauses is going to be our main topic today. We may also get on to what we call vitiating elements, such as misrepresentation, duress and undue influence, etc., which can affect a contract. Okay, so I haven't got the PowerPoints, but very quickly on classification of terms. Remember, there are 3 different types of terms. You can have a warranty, breach of which gives the innocent party the right to damages only, but not to terminate the contract. Conditions, of course, breach gives the innocent party the right to terminate the contract and claim damages. Talking about damages, damages is the main remedy for breach of contract, and we'll be covering remedies later on in our course. Okay, good. Remedies are very good, so if things go wrong, fix it up. Okay, just like me, I got fixed up, didn't I? Okay, and then we have, that's from Wallace and Pratt way back in 1910 on page 80 of your course manual. Okay, and then innominate terms. Innominate terms are, that's what makes things a little bit complex here. Lord Diplock in the Hong Kong fur case sort of muddied the waters slightly. He says that there is a third type of term which we cannot classify as either a condition or a warranty. So we will have to have a look at the effect of the breach of these intermediate or innominate terms, and the test, remember in PowerPoint 11, is that is the other party deprived of substantially the whole benefit? Key word there is substance or substantially. Okay. Are you a man or woman of substance? Okay, good word. Okay, and so that's the test. The court will look at the effect of the breach, and if the innocent party is deprived of substantially the whole benefit of the contract, then they'll treat it as if it's a condition. If not, they'll treat it as if it's a breach of a warranty. So not too bad, okay, but make sure you know that test for, if you like, classification of an innominate term. It's the effect of the breach. And one more time, is the innocent party deprived of substantially the whole benefit of the contract? And then with regard to actually classification of terms, how do you know whether a term is a condition or a warranty? Sorry, I just kicked a wire here. I've got all sorts of wires sucking from. Okay. Well, remember, the courts will look for the intentions of the parties. And how do you know the intentions of anybody? From the words they use. And normally that is conclusive. But we do get situations in which the words are not clear. Remember Lord Denning's famous saying, language is not an instrument of mathematical precision. And that's why we have lawyers, because lawyers are good with words, and we can sort out what the meaning of the words is. Okay. So Schuller and Wigman, yes, that's an interesting one. The court said labels were not conclusive, although the parties did describe this particular clause as a condition. The court said, well, hang on, the fact that the other party had to make 1 visit a week for a number of years, they missed 1 visit out of 1,400, and the court said, well, hang on, sort of common sense, if you like. That shouldn't allow the other party to terminate the contract for such a trivial breach, 1 out of 1,400. And so the court sort of rationalised it. They said, well, even though you use the word condition, you're not using it in legal or technical sense. And everybody said, well, hang on, condition is a condition, isn't it? Anyway, and so Lombard and Butterworth, the Court of Appeal, said, well, we will give a lot of weight to the actual words used, and if, for example, a clause says time is of the essence, then that will go to the root of the contract, and that will be treated as a condition. And you also got on page 81 the Hong Kong land case of Union Eagle and Golden Achievement, in which somebody was 10 minutes late. Like Philip, you were how many minutes late? 5 minutes late. Oh, that's all right, not 10 minutes. Okay. Well, was that sufficient for the innocent party to terminate the contract? And the court said yes, because it was a condition, because it goes to the root of the contract. Okay, and so in the Union Eagle and Golden Achievement case, the innocent party was able to terminate the contract and claim damages. And the quantum of damages was actually the deposit itself. This is more land law than contract law. In land law, when you buy a flat in Hong Kong, then you put down a deposit. And the issue in Union Eagle was whether that deposit was a liquidated damages clause. What do you mean by a liquidated damages clause? Well, we'll cover that when we deal with remedies, but you can have a clause in a contract which says that if there's breach, this is how much money the innocent party will get, which the courts like. Well, that's good, but there are restrictions on that. It has to be a genuine pre-estimate of loss before the courts will decide that it is a genuine liquidated damages clause. So the issue in Union Eagle and Golden Achievement was that deposit, which was 10% of the purchase price, was that a forfeitable deposit? And the court said it was. And they said, well, if the deposit was 10% or less of the purchase price, no problem, that is a liquidated damages clause. If the deposit was greater than 10%, well, the court said, well, that will not be liquidated damages clause unless the vendor, the seller, can establish special or exceptional circumstances. Okay, so that's Union Eagle and Golden Achievement on page 81. Time of the essence. Okay. So the court said, well, that is a condition. But of course, if you want to make sure that a clause is a condition, spell it out. And you can say, you know, breach of this clause will entitle the innocent party to terminate the contract and claim damages. Well, that would be construed always as being a condition. Also then, of course, what about other wording? Rice in your mouth, are you hungry? Where a breach, the contract said that every term was a condition. The court said that doesn't make commercial sense. Okay, so with regard to classification of terms, the courts will always look for the intentions of the parties. They'll look at the wording first, and if the wording is clear, they'll follow it, unless there are extreme consequences, as in Schuler, or contrary to commercial sense, as in the Rice case. Okay. With regard to intermediate or innominate terms, so those cases on page 82 are instructive. The Hong Kong Fur shipping case, the courts looked at particular wording, and in Hong Kong Fur, the wording was that the ship would be in every way fitted for ordinary cargo service. So was that a condition or was it a warranty? Because we don't know. So the look at the effect of the breach. Was the innocent party deprived of reasonable use, reasonable benefit of the contract? The court said no, it wasn't. It was an engine. It wasn't. It was a bit old, but the ship could still operate okay. And the court found that it was not sufficient to terminate the contract. Also in Yam Seng, the wording was that goods would be shipped promptly. And the court said this is, what do you mean by prompt? Okay. And so the court found that this was an intermediate term, and they looked at the effect of the breach. Okay. So the answer to that is be careful what words you use. Words do have meaning. Okay. So that's a quick review of classification of terms. But now we're going to spend the majority of today on exemption clauses. Okay. And everybody, check your toolkits. You know what I mean. Must know definitions. Do you know the definition of an offer? Yes, you do. If you don't, you've got a bit of work to do. Acceptance, consideration, and now we've got exemption clause. So what is an exemption clause? Well, almost what's on the screen. An exemption clause is a term in a contract. So I'm just see if I can make this a bit. Oh, there you are. Isn't that exciting? The way you can move these things around. There you are. Okay. Oh, by the way, we've got the chat box open. So if you want to send some questions or comments, then drop me a line in the chat box. Also, I've got a note from Cheng Hon Man. Good afternoon, sir. Would you mind telling me about the handout in Sol 2 website that is being updated? I'm sorry, I've no idea what that's all about. Some of you might know, so you can let Mr. Cheng know. If not, maybe I can try and find out from Christine or somebody in the office what that is all about. Okay, so let's get on to exemption clause. What is an exemption clause? Put this in your toolkit, must know definitions. An exemption clause is a term in a contract. Well, actually, I haven't got the definition, but it actually comes up the PowerPoint form. I'll tell you it now, and I think it's good to write it down. An exemption clause, sort of on the screen, seeks to exclude or restrict liability of one of the parties in specified circumstances. Good. But a better definition is this: an exemption clause, also called an exclusion clause, same thing, is a term in a contract that seeks to exclude or restrict liability for either breach of contract, misrepresentation, or negligence, full stop. That, I think, is the must-know definition. Okay, well, perhaps I should have a PowerPoint there, but it's sort of what's on the screen. So I'll say again, everybody, this is a must-know definition. An exemption or exclusion clause is a term in a contract that seeks to exclude or restrict liability for either negligence, misrepresentation, or breach of contract. Now, of course, we haven't covered misrepresentation yet. We haven't covered negligence yet. Breach of contract is where one party has not performed their obligations under a contract. Okay, so make sure you know that definition, not just know it word perfect, but understand what it is. Now, by definition then, what is an exemption clause? A term which seeks to exclude or restrict liability for either negligence, misrepresentation, or breach of contract. So where does an exemption clause fit in? The answer is it is raised as a defence. That's a very important point to make. It's raised as a defence to what? A claim for either negligence, misrepresentation, or breach of contract. Make sure you understand the civil procedure, if you like, in that a plaintiff can sue for breach of contract or negligence or misrepresentation. But the other party can say, oh, no, I've got a defence. What is your defence? There's an exemption clause in the contract. Go and read it. And the exemption clause will be trying to exclude or restrict liability for either negligence, misrep, or breach of contract. So there are two types of exemption clauses. There's, if you like, a full exemption clause. The one that seeks to restrict liability is called a limitation clause. Okay, and it restricts liability to what? Normally a sum of money. Okay, and I've got a case there called Ailsa Craig, which we'll come to a bit later on. Note also, when it comes to exemption clauses, make sure you read the wording of the clause very carefully, because this has consequences. The exemption clause may not actually use the word liability. It can also use the word responsibility. We will not be responsible, okay, for negligence, breach of contract, or misrep. Or we will not carry any risk, okay, or we will, So I challenge you, everybody, when you go out exercising, in nice weather to be exercising, look around. Check out notices. You may well find an exemption clause and have a look at the wording. Okay. For example, you could say you could enter a building. Everybody entering here does so at their own risk. Well, that's a type of an exemption clause. Okay, so that's what it is. Must know the definition of an exemption clause. A term in a contract which seeks to exclude or restrict liability for either misrepresentation, negligence, or breach of contract. Okay. So, and remember, an exemption clause is raised as a defence. Okay, so sort of a bit of philosophy now in this PowerPoint. Mate, why do we have exemption clauses? Well, the answer is because it does help allocate risk under a contract. So the contract can say such and such things happened, you'll be responsible for this. Therefore, what might you do? You might cover yourself by taking out insurance. Okay. Also, it does help reduce litigation costs so that when you go and buy something, for example, you don't have to sit down with the seller and painstakingly go through every clause in a contract. So it enables mass production of standard form contracts, which obviously reduces the cost of negotiations and of making contracts. Okay, but of course, when it comes to exemption clause, it's normally the powerful multinational companies, the suppliers, they have all the bargaining power. We consumers don't have much bargaining power. And so the courts are very keen to protect you and me, the consumer, from these powerful companies. And so you'll see from the case law, which we're going to go through in a moment, how they do this. But the main protection, not the only protection, but the main protection these days is in legislation. So everybody, isn't this exciting? We're coming to our first piece of legislation called the Control of Exemption Clauses Ordinance, the CECO. So about to go through that. Now you might say, well, hang on. How much do we need to know of this ordinance? Well, I'll let you know. There are only sort of 2 or 3 sections I think you should know quite well, but you need to know in general terms what the CECO is trying to do. It's basically trying to protect you and me from greedy suppliers. Okay, so let's move on. What's on the screen, everybody, is sort of a helicopter view, overview of all you need to know about exemption clauses. So this is a good PowerPoint. Remember, my PowerPoints are good. No such thing as a perfect PowerPoint, but this one's pretty good because it's got all you need to know in one PowerPoint, but of course lots of details you'll have to fill in. Okay, so the first point, of course, is if you're doing any question in an exam, either with a sort of a bookwork type question in part A of the exam, or perhaps part B of the exam, you could get a question dealing with exemption clauses. Well, make sure you know an exemption clause when you see one, okay? And of course, you know what an exemption clause is if you know the definition. What is the definition? An exemption clause is a term in a contract which seeks to exclude or restrict liability for what? Either misrepresentation, which we may actually get onto today, everybody. I'll possibly get onto misrepresentation today. Negligence or breach of contract. Now, of course, negligence is also a tort, and it's the main tort we study on this course. But briefly, what is negligence? Well, negligence is where somebody owes, O-W-E-S, a duty of care, and where the defendant owes a duty of care to the plaintiff, and the defendant is in breach of the duty of care, causing damage to the plaintiff. They are the elements of negligence. So it's a duty of care owed by the defendant to the plaintiff, then there's breach of the duty causing damage. It's almost A, B, C, D. A, duty of care, breach of the duty of care, causing damage, causation, and D, of course, is the damage. All right, so there you go. Easy as A, B, C, D. All right, so that's negligence, and of course, breach is breach of contract. Okay. But remember, where does the exemption clause fit in? It's raised as a defense to a claim for either misrep, negligence, or breach of contract. Will the exemption clause be effective as a defense to any of those claims? That's the big issue. And the answer to that question is in points 2, 3, and 4 on the screen. In order for an exemption clause to be effective, it must pass 3 tests. One is called the incorporation test. What do you mean by that? Well, corpus is the Latin word meaning body. So is the clause incorporated in the contract? Is it in the contract? Well, how do you incorporate an exemption clause into a contract? Well, there are 2 main ways. One is by signature, and the other one is by notice. Okay. Notice sort of has a subset called course of dealing. Okay. The second test that an exemption clause has to pass in order to be effective as a defence is, if it is in the contract, does the wording cover the breach? Does it cover the legal wrong? And this is a matter of interpreting or construing the wording of the exemption clause. Okay? And the courts will look at the wording of an exemption clause, and if there's any ambiguity in the meaning of the words, they will construe it or interpret it strictly against the person relying on the exemption clause. And that's called the contra offerentum rule. Okay, a bit of Latin. Contra means against. Offer means against the person relying on the exemption clause. So the courts will scrutinise very carefully the wording of an exemption clause, and if there's any ambiguity at all, then they will construe it against the person relying on the exemption clause. So we'll look at some cases on that, and some of the cases, the courts were very extreme in their interpretation of the wording of an exemption clause. Okay. And of course, the main reason is to protect you and me, the consumer, from unscrupulous suppliers. Then along comes legislation. Now, in England, there was legislation called the Unfair Contract Terms Act, 1977, I think it was. And Hong Kong has followed suit, and the Control of Exemption Clauses Ordinance mirrors quite closely the wording of the English legislation. Although Hong Kong has a much better name for the legislation because it's called the Control of Exemption Clauses Ordinance. So what is the ordinance trying to do? Control exemption clauses. Well done, Hong Kong. Good name of the legislation. In England, the exact same legislation is called the Unfair Contract Terms Act, which is a really stupid name because the Unfair Contract Terms Act doesn't apply to all contract terms. It only applies to exemption clauses. Also, what is the effect of the legislation? Well, as we'll see in a moment, the effect of the legislation is to render an exemption clause either totally void, of no effect at all, or makes it subject to a test of reasonableness. I always have trouble saying that, reasonableness. And so the English legislation is a bit stupid because it says Unfair Contract Terms Act, whereas the test is actually not fairness, it's unreasonableness or reasonableness. Okay, so everybody, whenever you're dealing with exemption clauses, remember what is an exemption clause, know the definition, and then appreciate where the exemption clause fits in. It's raised as a defence to a claim for either misrepresentation, negligence, or breach of contract. So, big issue is the exemption clause effective as a defence to such a claim? Well, the answer is points 2 and 3, 2, 3 and 4. Well, it's got to pass the incorporation test, it's got to pass the interpretation or construction test, and then it also has to fit in or comply with the legislation. So if you're doing any exemption clause answer, it's good to have subheadings. You could put down the definition of exemption clause, then you would have incorporation, construction, legislation. Good to have subheadings when you're answering exam questions because it helps you focus on the particular issue at hand. Also, by the way, it's very good for examiners like me, because then I know what you're writing about. Okay, I've mentioned exam technique briefly before, but when you're answering law questions, be aware of the structure of your answer. Highlight your cases and legislation. Now, how you do that depends on what you're using. If you've got a computer, of course, bold the cases and the legislation. If you're writing it, underline the cases and the legislation. Also, you should have subheadings, and the best subheadings are always issues. What is an issue? You know, an issue is a question for the court to decide. So remember, that's your main skill as a lawyer, identifying issues. It's interesting, the new Chief Justice, Andrew Chung, when he gave his speech at the start of the legal year, did actually mention that word issue quite a few times. We are lawyers, we look for the legal issues, and we decide it according to the law. Okay? So everybody, make sure you know what an issue is and how do you identify the issue? Well, by using definitions. That always helps. All right. Okay, on the bottom of the screen, I've got section 5 of the CECO. I'll probably mention this a bit later, but briefly now, in that when the legislation was brought in, who were the people who were unhappy? Well, the answer is the suppliers. And of course, who are the people who draft these contracts containing exemption clauses? The suppliers. So they said, well, hang on, we don't want to be caught by this legislation because it's pro-consumer. So what we will do is we will word our clauses, exemption clauses, but we'll use wording which sort of hides the fact that it is an exemption clause. For example, you could have a clause in a contract saying, okay, we will be liable for breach of contract, but you will have no remedies. What? Or, we will be liable for negligence, but you've got to make your claim in writing within 30 minutes of any claim arising. I mean, in other words, they attach restrictive or onerous conditions to any plaintiff making a claim. And so the legislation catches this. Section 5 of the CECO attempts to catch these, what I call wolves in sheep's clothing. Now, it's been pretty cold, hasn't it? I mean, you've been walking around with plenty of layers. Not so much today, a bit warmer today. But normally when I'm in class, normally it's the ladies who have these nice woolly coats on. And I say, well, hang on, if you take off your coat, is there a wolf underneath? Okay, of course. And so remember, these clauses are dressed up so they don't look like exemption clauses, but, look a bit deeper. And you find, hang on, there's an exemption clause hiding under that. Okay, so a wolf in sheep's clothing. That's what I mean by that. And remember, it's the suppliers trying to avoid the application of the legislation. Section 5 of the CECO, everybody, is going to be should know, not must know. Okay, I'll tell you what the must know sections of the CECO will be when we get there. All right, so that sets up the scene nicely, everybody. This is our overview of exemption clauses. Number 1, make sure you know the definition. Word perfect. Okay, what is it? You should be able to tell me. Okay, a term in a contract which seeks to exclude or restrict what? Liability or responsibility or risk for what? Misrepresentation, negligence, or breach of contract. Okay, we will be covering misrepresentation when we start in the next chapter on vitiating elements, possibly even today, and misrepresentation will be the 5th must-know definition for our course. Okay, there are only 6, so we're getting there. The last must-know definition for contract will be frustration. Okay. So there you are, everybody. Exciting, isn't it? We have other definitions to come. We've got 4 out of the 6 already. Hope you're feeling confident now, because these definitions are the foundation of your knowledge of contract law. Okay, so let's get on to points 2, 3, and 4 in a bit more detail. Remember, the big question here is the exemption clause effective as a defence to a claim for either misrep, negligence, or breach of contract? Well, the answer will be it will only be effective if it passes the 3 tests of incorporation, construction, and legislation. Okay, so good, useful subheadings if you're dealing with exemption clauses. Okay, first of all then, incorporation. How can an exemption clause be incorporated in a contract? In other words, put in the body of the contract. Well, it can be incorporated by 2 methods. One is by signature, and the other one is going to be by notice, stroke, course of dealing. Okay, by the way, it's worth noting that the burden of proof is on the party trying to enforce the exemption clause. So the defendant, because you'll be suing them, and the defendant will have the burden of proving that the exemption clause is actually in the contract. Okay, so let's have a look at incorporation by signature. must-know case is Lestrange and Grocott. Must-know, Lestrange. And in Lestrange and Grocott, which is on page 84 of the course manual, you got the facts there. The exemption clause in question was in small print and very difficult to read. Okay, I don't know about you, everybody, but I've got a number of magnifying glasses at home. Okay, I'm going blind, but anyway. Any good lawyer has a good magnifying glass. Okay, so this is what happened in Lestrange. The exemption clause was in small print, very difficult to read. The plaintiff sued for breach of contract, claiming the exemption clause was not part of the deal because he had no notice of existence. The Court of Appeal held that since the contract was signed by the plaintiff, the exemption clause was duly incorporated into the contract. In the absence of fraud or misrepresentation, whether the plaintiff had actual notice of it was irrelevant. Which means what, everybody? If you sign a contract, you are bound by all the terms in the contract, okay? Even though you haven't read the contract, which means what? Make sure you read the contract. And if you don't agree with any of the terms, then perhaps you should have it amended, or you negotiate to change it somehow. Okay, so Lestrange and Grocott, everybody must know Lestrange, which says if you sign a contract, you are bound by all of the terms in the contract, even though you haven't read it, unless there is some form of fraud or misrepresentation. Okay, Lestrange is your must-know case. A sort of should-know, might-like-to-know case is the bottom one, which is not in the course manual, but Tilden Rent-A-Car in Glendenning. I like this one because pre-COVID-19 days, I was in the habit of flying places down to Sydney and hiring a car straight from the airport and then driving 200 odd miles west over the mountains in Australia. I mean, I was younger then, wasn't I? On no sleep driving. Anyway, then they changed the system at Sydney Airport, so you couldn't hire directly from the airport. You had to go. So anyway, because this is what happened in Tilden Rent-A-Car. Somebody had landed at the airport, and you know, how do you feel when you land after a long flight? Well, you're not very happy. You're a bit tired and being cramped up, etc. And so the person who landed at the airport in Ontario went to hire a car, rent a car, and the person who was renting it said, please sign, don't worry about reading it, nothing there you need to worry about. Okay? And the person signed the contract because there was something wrong with the car, and so he sued for negligence, and but the supplier said, no, you signed the contract. And the court said no, because there was some form of misrepresentation here in that the person who was hiring out the car said, you know, don't worry about it. You've got nothing there that you need to be concerned about. Okay, just sign the contract and away you go. I know you're tired. Okay, just sign it and off you go. But it's a very weak decision. Number one, it's Canadian, so not binding in Hong Kong, and it's only Court of Appeal, and it is a split decision. In other words, not all the judges agreed. Okay. So, I mean, I just like that one. Tilden's an interesting case, and I mean, we should look at some cases which are not must-know. Lestrange is your must-know case. Must-know. Okay, how do you remember the case name? Well, it's strange, yeah, but it's Lestrange. Remember what the ratio of Lestrange is. If you sign a contract, you are bound by all of its terms, even though you haven't read the contract, unless there is some form of fraud or misrepresentation. Okay, good. Now, the second method of incorporating an exemption clause into a contract is by notice. Now, lots of cases here, and some of them quite interesting, but really there's only one must-know case, and it's the first one. Parker and South East Railway is the only must-know case here, because Parker, which is on page 85, where's Parker? I've got 85 in my notes. Where's 85? Where is Parker? Oh dear. Yeah. Maybe it's over the page. I can't. actually, I didn't write this course manual. I've actually written some course manual, but if I was writing this course manual, I'd put all the cases in bold print so you can see them easily. Anyway, I thought Park was on page 84. Anyway, it's not there. All right. Yeah, there is another case called Thompson and London, Midland and Scottish MS. I'm not sure what MS stands for. Railway. Pretty old case, 1930. Okay, but I like Parker. Parker is your must-know case, even though it's not quite in your course manual. Parker and South East Railway laid down the test, and the test is there. Did the party, relying on the clause, take reasonable steps to bring it to the notice or attention of the other party? Did the party, relying on the exemption clause, take reasonable steps to bring it to the notice of the other party? Well, that depends on the circumstances of each case. So each case is different. Okay? So Parker gives us the test. So I like Parker. Also, Peter Parker is Spider-Man. Yes. Also, Parker is my mother's maiden name. Anyway, so I like Parker. Thompson sort of says the same thing. Now, let's have a look at this. Applying the Parker test. Did the party, relying on the clause, take reasonable steps to bring it to the notice of the other party? Chapelton and Barry is an interesting case. So every time you sit on a chair, think of Chapelton and Barry. I'm sitting on this chair now rather precariously. I don't know what's wrong with the floor in this room. I can't move my chair that well. I'm on a swivel chair. But in Chapelton and Barry, somebody hired a deck chair. And they sat on the deck chair and it collapsed. I've actually done this in class. I've sat on a chair and fallen off it, nearly did injure myself. And so the person who hired the deck chair sued the person hiring out the deck chair for negligence because they got injured. Okay. But then the person hiring out the deck chair, no, we have a defence. What defence? There's an exemption clause. Where is the exemption clause? Well, they said, well, have a look at your ticket. And the court said, hang on. You have not taken reasonable steps to bring that exemption clause to the notice of the person who hired the chair. You don't expect to see an exemption clause on a receipt. Good point. Okay. So in Chapelton and Barry, the court found that the exemption clause had not been incorporated by notice. So every time you sit on a chair which is slightly unsafe, think of Chapelton and Barry. Okay. Ollie and Marlborough Court is another interesting case in which a young couple hired a hotel room and they signed the contract in the lobby and then went up to the room and the exemption clause was actually in the room. And then I'm not sure what happened. I think, yeah, your course manual does have Ollie. Is Ollie there? Yeah, there is bottom of page 84, my 84. Plaintiff entered into a contract for the use of a hotel room, signed the contract at the reception desk. An exemption clause purporting to exclude liability for lost luggage. Have you ever lost luggage? Was displayed in the hotel room only. The court held the exemption clause was not incorporated into the contract because the plaintiff was not aware of its existence when he signed the contract. He signed the contract in the lobby. I always sort of let my mind run a little bit loose with regard to Ollie. I mean, how would you go if you hired a hotel room, you're with your loved one, and then you're checking room and you say, what are you doing? Oh, I'm looking to see if there's an exemption clause above the bed, dear. Anyway, I like Ollie. I like that. And of course, we can't travel at the moment, can we? Well, not easily. And so it's nice to know that we used to be able to travel and hire hotel rooms. Okay. There are other cases. I remember the main case again, Parker. Did the party relying on the exemption clause in Ollie take reasonable steps to bring it to the attention of the other party? In Ollie, the court said no, because they'd already signed the contract. Okay. All right. Hang on. Packaging is saying, I'm not sure what's that all about. Okay. So that's Ollie. And then Hoiking container, not in your course manual. Hoiking is just a Hong Kong case in that the courts, I think the Hoiking container was actually an interesting one. Is that the Parker case? I have no idea. But Parker and Southeast, you don't really need to know the facts of Parker because you accept to know what the test. You know what the test is, everybody. Did the party, relying on the clause, take reasonable steps to bring it to the notice of the other party? Well, what is reasonable? Good question. Reasonable is such a open-ended word. It really just depends on each circumstances. That's all you need to do. And of course, if you're not sure, use your magic. Two-letter word. If it was reasonable, fine. If not, not fine. Okay. Sorry, I'm not sure about that reference there of open edu. Anyway, you can look it up, everybody. Why not look it up? Parker. I mean, it's so easy to look up cases these days. Parker and Southeast Railway. But you don't need to read the whole judgment. All you need to do is read what's in my PowerPoint at the top. Okay. Appleton and Barry, Ollie, and indeed Hoyking Containers. I think there was an exemption clause, and I think there was an issue of whether it was had been put in both English and Chinese, which is interesting. I mean, in Hong Kong, when I go hiking, you see these little flat things on the end of poles or sticks. I couldn't figure out what these things were, and there was a sign when I first saw it. It was only in Chinese, and then yesterday, I think it was, when I was sort of walking around Moi Wau, one of those villages, I saw a sign which actually was in English and Chinese, because in Hong Kong, we're a bilingual, if not trilingual society, and yes, it's for putting out fires. Okay, so if you're going to have an exemption clause, make sure it's in the right language, and if it's if you're in a bilingual society, it should be in both languages. Okay, so that's Hoyking Containers. And then other cases, again, just illustrating the principle. The principle is the party relying on the clause, did they take reasonable steps to bring it to the notice of the other party? In Chappleton and Barry, no, it was not reasonable to put an exemption clause on a receipt. In Ollie and Marlborough, no, because they already signed the contract in the lobby. The exemption clause was not in the contract, it was in the hotel room. Okay, all right. And then other cases, Thompson and Shoe Lane parking. When you go into a parking lot, you get the ticket, and it may well be the exemption clause is inside the car park. Well, then that would not be reasonable steps taken, okay? Because the contract has been formed before the notice was given. Photo picture library. Again, this one, Thornton is in your course manual on page 85. These other cases are not, but again, just illustrations. In Interphoto Picture Library, it was photo transparencies which had been returned late, and there was an extortionate fee for late return of these photo transparencies. And it had not been brought to the notice of the defender. Similarly, in Spurlaw and Bradshaw, Lord Denning says there are some contracts so widely drawn and so extensive in their effect that extra steps have to be taken to bring it to the attention of the other parties. And it's a so-called red ink, red hand rule. You know what I mean? You might watch out for when you pass notice boards. Sometimes you have this big red arrow, or maybe even a flashing light. Look at this, latest notice, etc., etc. Okay. Mind you, I'm in Admiralty Centre at the moment. I'm always reading notices. Not allowed in this room, not allowed in that room. Okay. Maybe they should have red ink notices. This is the latest notice on COVID-19. You're not allowed to keep more than social distancing. So Spurling and Bradshaw, Interphoto simply say, well, I mean, if the exemption clause has such widespread effects, then extra steps might have to be taken to bring it to the attention of the other party. Chan Woong Hong, again, is a case dealing with translations, in that the exemption clause will only be effective if it's in the same language as the person who is the other party to the contract. So you'll only be bound by the parts which actually are translated into your language. Okay, good. Again, now everybody, the only must-know case is Parker. Parker's your must-know case in South East Railway, and it lays down the test. did the party relying on the exemption clause take reasonable steps to bring it to the notice or attention of the other party? And that depends on the facts of the case. Okay, there was another interesting one too, which I haven't got here. When you go online, okay, and you order something, sometimes people say, if you're buying this, terms and conditions apply, go to another link, another website, and read it. And the court said that is reasonable. So if you are applying terms, including exemption clauses, and they apply to purchase of goods online, eBay or whatever, and the website says, other terms apply, and you have to go to another website to read them. Well, the court said, well, that would be reasonable because it follows the Parker principle, if you like. Did the party relying on the contract take reasonable steps to bring it to the attention of the other party? And in that other case, which we don't need to worry about, the courts, I think it was a music company involved, the court said that reasonable steps had been taken. So all these cases are interesting, but you only need to know one must-know case, Parker and South East Railway. No need to look up the whole judgment. Just remember what I've told you, that's the ratio of the case. All right, now we get on to the second bit. Let's go back a little bit, because everybody, we are looking at, where is it? Point number 3 now. We've covered point number 2. How do you know whether the contract is in the clause is in the contract? Well, has it been incorporated either by signature, Lestrange and Grawcobb, or by notice, Parker and South East Railway? I've also got some course of dealing. That's sort of a subset of incorporation by notice, in that if you've been dealing with a particular company on the same terms for over a certain period, the courts will say, well, that will be incorporated by course of dealing. Okay, so again, it's just the same as notice. Okay. All right. Let's go on to point number 3. Incorporation, if the exemption clause is in the contract, does the wording cover what you're trying to exempt liability for, whether it be misrepresentation, negligence, or breach? Okay, so where are we? Here. So that's the test. Does the wording cover the breach? And when I say breach, I mean legal wrong. It could be breach of contract, could be negligence, or be misrepresentation. Okay, so again, it depends on what the wording is, but if there's any ambiguity in the wording, any vague wording, the courts will interpret it against the person relying on the exemption clause. This is called the contra profferentum rule. And some interesting cases here, Andrews and Singer, on page 87, Andrews and Singer said what? I think it was a clause excluding liability in relation to implied terms was held in Andrews and Singer Brothers to be ineffective for excluding liability for breach of an express term. That's a good one. Okay. Remember, terms in a contract should be expressed, but there are also other terms which might be implied. Okay, so that's Andrews and Singer Brothers. So an exemption clause covering breach of an implied term did not cover breach of an express term. Okay, and it was a used car which was delivered when there was an express term to deliver new Singer cars. Okay. Also, an exemption clause covering breach of warranty does not cover breach of condition. I mean, don't worry about those 2 cases on the screen, but that's, again, just an example of the contra profferentum rule. Also, there was another case called Houghton and Trafalgar, which I haven't got a PowerPoint on, but Houghton and Trafalgar was... the courts were looking at the wording which says, looked at the word if you have a car built for 5 people and there are 6 people in the car, is that overloading? No, the court says it's not overloading, it's overcrowding. And the courts are splitting hairs with this because they want to come up with a decision which favours the consumer. Okay. All right, so that's all very well. So before the legislation, the courts were very, very keen to interpret wording in favour of the consumer. So this is why in Andrews and Singer Brothers, that exemption clause was not effective. But along then comes the legislation. Now, I think the legislation in England was 1977, and then the leading case now on interpretation is the House of Lords decision in Ailsa Craig and Morven Fishing. Now, what happened in the House of Lords case of Ailsa Craig is that the court said, we now have legislation in England, and in Hong Kong, the CECO was enacted in 1990, so the same thing now. And the court said, well, now because we've got legislation which is an extra layer of protection for consumers, we don't have to, interpret the wording of exemption clauses so strictly. So the court in Ailsa Craig says the court should not strain the meaning of words. Relevant words must be given their plain, natural meaning. Okay, and there's a Hong Kong case, Ying Wai and Nanyang Credit Card Company, which says that. Got Ningyan? No, not in the course manual. Unfortunately, it should be. In Ningyan, that's just an example of that. Also, limitation clauses will not be construed as strictly as full exemption clauses because of the nature of a limitation clause. What is a limitation clause? It is an exemption clause, but it's not trying to exempt liability totally. It's only restricting liability, and normally that is to a certain sum of money. But the court did say if you want to exclude liability for negligence, it can only be excluded by clear words. So Ailsa Craig is just simply the courts looking at the situation after legislation was enacted and saying, well, we don't need to be so strict on interpreting the wording of exemption clauses anymore. We will not strain the meaning of words, as in Houghton and Trafalgar. Okay, 5 people in a car built for 4 is not overloading, it's overcrowding. I mean, okay. So that's so when it comes to interpretation, the only must-know case is Ailsa Craig. The court's not going to strain the meaning of the language. Okay, the court give the words their plain and natural meaning. That's the main point about Ailsa Craig. Now, I hesitate to cover this because what's on the screen, everybody, is history. It's gone. Okay, the main issue in these cases was, can you exclude liability for breach of a term which goes to the root of the contract, a so-called fundamental breach? The answer is yes, you can. That's basically what this is all about. So this was a bit of an argument, an academic argument. And so there were these cases, Casales, and also photo production, and the House of Lords in photo production. Yes, you can have an exemption clause for excluding liability for breach of any term in a contract. That's basically what it says. So what's on the screen, everybody, forget it. Might like to know, it's history, it's gone. So why have I got it there? Good question. Well, the answer is because it's in your course manual and on page 88, but you should be ignored, okay? In fact, it's even in my contract law book, but it's all history. Don't worry about what's on the screen. Okay, it's just sort of used to be, well, passing interest. I might like to know, that's all. One interesting case, though, on misrepresentation of an exemption clause. Curtis, on page 84, somebody took a wedding dress to the dry cleaners to be cleaned, and the person at the dry cleaner says that the exemption clause covered liability for damages to sequins and deeds only. Okay, fine. As it turned out, the exemption clause covered any damage to the wedding dress, but the person who was making the statement has actually made a misrepresentation. They're saying, don't need to read anything. The exemption clause covers just liability for breach, rather sensitive items, the sequins and beads on a dress. But as it turned out, the exemption clause covered any damage to the dress, and so the court found that the exemption clause was not effective because there was a stain on the dress. Oh dear. Of course, I guess wedding dresses, most of them are white. So any stain would not be nice, would it? Which reminds me, I've got a stain on my black coat at the moment. I must try and get rid of it. Oh dear. Okay, so Curtis is a should know case, not must know. Okay. Now we get on to legislation. Okay, so legislation quite important. Sorry, oh, it looks like I need a drink, which is interesting. Well, let's cover this PowerPoint first, and then we'll have our first 10-minute break. So remember, well, let's go back to the blueprint. Where's the blueprint? Number, I should know the number. Yeah, well, not there. It's number 4. Okay, so everybody, where have we got with exemption clauses? Number 1, know the definition. Number 2, how the exemption clause will be raised as a defence to a claim for either negligence, misrepresentation or breach of contract. How do you know whether it's effective as a defence? Well, it'll only be effective if it's actually in the contract, incorporated in the contract, either by signature, Lestrange and Grawcobb, or by notice, Parker and South East Railway. Okay, and even if it is in the contract, does the wording actually cover what you're trying to exempt liability for? Well, that's a question of interpreting or construing the wording of the exemption clause. Okay, but remember, the courts are not so strict anymore. Ailsa Craig and Malvern Fishing is your must-know case on construction. And then last but not least, we come to the legislation. So, if the legislation applies, and we'll have a look at how do you know whether that applies or not, then if the exact legislation does apply, it will render an exemption clause either totally void or make it subject to the reasonableness test. Okay, so that's point number 4. So I think we'll have a break now. After the break, we'll come back and look at the legislation, the CECO. So let me make a little note here. Okay, welcome back everybody. Hope you had a good little break there. Yes, so we'll have another 10-minute break in about, well, where are we now? 3, 4, around about 4:30. We'll have another short 10-minute break as well. Okay, so before the break, we're looking at exemption clauses or exclusion clauses, same thing. And remember what an exemption clause is. You know, don't you? An exemption clause is simply a term in the contract. I mean, the contract could have hundreds of clauses in it, so the exemption clause is just one of these clauses, but it's trying to do a big job. It's trying to exempt, whoops, sorry, what happened there? Try to exempt liability. And remember, the word liability might not actually show up. It could actually be responsibility or risk. For what? Either misrepresentation, which we haven't got onto yet, but there is a must-know definition of misrepresentation when we get to it, possibly today. Negligence or breach of contract. And so remember, the exemption clause is raised as a defence to a claim for either misrep, negligence or breach. Will it be effective as a defence? Okay. So make sure you know where the exemption clause fits in. It's raised as a defence. So you've been sued for breach of contract, for example. Well, what's your defence? Well, I can raise my exemption clause as a defence. But will it be effective as a defence only if it's incorporated in the contract, either by signature, Lestrange and Groscom, or by notice, ARCA, okay? And if it is in the contract, does the wording cover the wrong? Well, that's a matter of interpreting the wording of the exemption clause. Remember, the courts used to be very, very strict on this. And if there's any ambiguity, it would be resolved against the person relying on it. That's the contra offerentum rule. But Ailsa Craig, the House of Lords English case, is the leading authority here, saying the courts are not going to be so strict anymore because there is an extra layer of protection for consumers, and this extra layer of protection is legislation. And the legislation in Hong Kong is the Control of Exemption Clauses Ordinance, which is what we're about to have a look at now. And if I get to the right PowerPoint, come on up. Where are you? Okay. So, what's on the screen, very important, because make sure you know, well, what's the CECO all about? Well, the name is quite a good name because the legislation is aiming to control exemption clauses. Well done, Hong Kong, with naming the legislation. And it applies mainly to consumer contracts, consumer meaning you and me, okay? But in certain circumstances, it may also apply to business contracts, where, for example, one business is dealing on their standard terms and the other business isn't, and it's not their normal business that they're in, okay? But usually it's there to protect consumers, namely individuals, against companies or suppliers who have much stronger bargaining power. Also, of course, the law wants to make sure that consumers are protected, particularly when you buy products which might injure you or even kill you. Okay, so that's the philosophy. And remember, the legislation was enacted, I think in Hong Kong, 1990. And if the legislation applies, it will make an exemption clause either totally void, that is of no effect at all, or make it subject to the reasonableness test. So the reasonableness test we'll look at in a moment. The reasonableness test, because of the name, it's reasonable, it's really up to the court. The court really has total discretion in deciding whether an exemption clause is reasonable or not, okay? But we'll be looking at, what sort of factors would the court take into account to decide whether an exemption clause is reasonable or not. Okay, so that's what the CECO does. If it applies, it will render an exemption clause either totally void or subject to the test of reasonableness. Now, Section 2 of the CECO does contain some important definitions. And Section 2, I think we're around pages 91, 92 of your course manual. Section 2, I'm not sure with Section 2 anyway. Section 2 contains important definitions, and one of them is what is the definition of negligence? Well, again, of course, we're ahead of ourselves here because we haven't covered negligence yet, but there is, if you like, the common law tort of negligence, but the definition of negligence in the CECO is a bit wider. It covers other types of behaviour. For example, it can cover an exemption clause which is just in a notice. Okay. Anyway, but Section 2 also talks about who is a consumer. Well, a consumer, where somebody is dealing in the course of a business and the other party is not dealing in the course of a business. Well, you and I, of course, would not be dealing in the course of a business, but somebody who's selling products would be. So then we would be a consumer. Okay. And probably the most important section for our purposes, I think everybody, the really only must-know section of the CECO would be Section 7. Section 7 does illustrate the operation of the CECO quite nicely. Oh, by the way, Section 2 is on page 93, dealing with the definition of negligence. Okay, it says any obligation arising from the express or implied terms of a contract to take reasonable care or exercise reasonable skill in the performance of the contract. Any common law duty of care, again, we'll cover that when we deal with the tort part of the course. And also common duty of care imposed by the Occupier's Liability Ordinance. What is occupier's liability? It's a special form of negligence that applies where somebody is in the control of a premises, and it imposes a duty on the person who controls the premises, a duty owed to visitors, people who are on that property with permission. Okay, but Section 7 is, as I say, a good one to look at because Section 7 illustrates quite nicely how the CECO works. And Section 7 is on page 94. So let's have a look at that. And it's the next PowerPoint. We'll jump back to the others later. But Section 7, hang on, I thought that was Section 7. Yeah. Okay. I'll come back. How come you're there? Go away. There we are, Section 7. Section 7, everybody, I think this would be must-know because it could come up in exams, and if you're dealing with a question on exemption clauses, it would be good to have a situation which illustrates how the legislation works. Remember, how does the legislation work? If it applies, it renders a contract either totally void or subject to the test of reasonableness. So with regard to Section 7, this deals with negligence, and Section 7 sub 1 says that you cannot exempt liability for negligence causing death or personal injury. Cannot, in other words, totally void. But Section 7 sub 2 says you can exempt liability for negligence causing other damage, such as property damage, if it is reasonable. Okay, so as I say, Section 7 is a good one because it's a very common one, of course. When you buy a product, let's say, I don't know, what would you be buying these days? Oh, a heater, for example. This has been so cold, hasn't it? If you buy a heater and it sort of catches flames and, injures you by burning you and also perhaps damaging your property, well, you could sue for negligence, and the exemption clause would be totally ineffective with regard to negligence causing your injury. Heaven forbid if it's actually death, all right? But the exemption clause might be effective as a defence for negligence causing property damage, and only if it is reasonable. So how do you know whether it's reasonable or not? Well, the answer is we've got to look at the reasonableness test. Now, so what we've covered, everybody, Section 2 and Section 7. Section 2 has got the definition of negligence, and Section 7 deals with trying to exempt liability for negligence. The other sections on the screen, everybody should know not must know. Okay, you might want to look through those if you like, but I'd say the only must know section of the CECO, in other words, good chance might come up in the exam, would be section 7. Perhaps also the sections dealing with the reasonableness test, which we're about to have a look at. Okay. The other ones, you can read through those for yourself, but more should know than must know. Can you exempt liability for breach of contract? That's possible. Depends on what type of contract it is. Also, manufacturer's guarantees. Also, if it's breach of a sales contract, that's covered by Section 11, as opposed to hire contracts. So you don't buy it, you only hire it. That's covered by Section 12. Read through those for yourself. Should know, not must know. Can you exempt liability for misrepresentation? Good question. That's covered in Sections 3 and Section 4 of the Misrepresentation Ordinance. And I've already touched on Section 5 before. Can you dress up your exemption clause so it doesn't look like an exemption clause? In other words, you have a clause in the contract with saying, we will be liable for negligence, but you've got to report to us, within an unreasonable short period of time, or by an unreasonable method, say in writing, for example. Or you could impose onerous conditions such as you will have no remedy. So that would be caught by Section 5 of the CECO, so-called wolf in sheep's clothing. Again, should know, not must know. I'd say it's really only Section 7 of the CECO, plus I think Section 3 and Schedule 2, because these deal with the reasonableness test. So we should get to grips a little bit with what on earth is the reasonableness test, and how does the court decide whether a clause is reasonable or not? What sort of factors will it take into account? So let's have a look at the reasonableness test. And Section 3 of the CECO covers this, and it's on page 91. And you'll notice top of page 91, it talks about Section 3 sub 1, doesn't take us very far, does it? It means the term shall have been a fair and reasonable. What do you mean by fair? What do you mean by reasonable? Very vague words, so it doesn't really help much. But I suppose the rest of the wording does help a little bit, okay, in that it's really up to the court. The court can take into account anything it is reasonable in the circumstances of the case. Also, if you have a look, top of page 92, this is a very important point, the strength of the bargaining positions of the parties. This is actually in Schedule 2, okay? So I'm reading the top of page 92, right at the top of 92, that's probably the most important factor the court will take into account, the strength of the bargaining positions of the parties relative to each other. And obviously, if you're a consumer, you don't have much bargaining power. So that's always a factor against an exemption clause being reasonable, okay? Also, the other factors there, the guidelines, whether the customer received an inducement to agree to the terms. So if you get a free gift or a discount, that will be a relevant factor. Whether the customer knew or ought reasonably to have known of the existence or extent of the term. Again, that's a matter of notice. Whether the term excludes or restricts any relevant liability if some condition is not complied with. And also whether the goods were manufactured, processed or adapted to the special order of the customer. Okay, so they're all guidelines set out in Schedule 2 of the CECO, which the court can look at. But basically, it's really up to the court. The court has total discretion here. Also, subsection 3, section 3, sub 3, talks about notices. And of course, any notice has to be noticeable, and it has to be, subsection 4, in the right language. So remember, bilingual society in Hong Kong. So for any exemption clause to be effective, it should be bilingual. Also interesting that subsection 5 is an interesting one. Subsection 5 said that whether a limitation clause is reasonable or not, the court will look at certain factors, in particular the resources of the defendant and also the availability of insurance. Okay? So that's a very important point, because a limitation clause normally limits the liability of the supplier to a certain sum of money. So the answer is that a reasonable sum of money? Well, it depends on the resources of the defendant and particularly availability of insurance. And then last but not least, section 3, subsection 6 deals with the burden of proof. And the burden of proof will be on the party alleging that the exemption clause is reasonable. Okay, so that's the reasonableness test. I mean, the word reasonable itself is so vague, okay? And really it's up to the court on the facts of each case to decide what reasonable actually means. But I think subsections 5 and 6 are quite useful, because with regard to limitation clauses, it's interesting the court will take into account these specific factors. How rich is the defendant, and also the availability of insurance. And also subsection 6 is always important, everybody, not only here but in lots of other areas of law, because who has the burden of proof? Remember, in civil actions, if you need to prove your case, if you have the burden of proof, you've got to prove it on the balance of probabilities, more likely than not. So if the evidence is equally weighed for and against a particular issue, if you have the burden of proof, you lose. Okay, so the burden of proof, quite important. BOP, burden of proof. Okay, now I've got a particular... Yeah, I've already covered negligence, okay. Section 7, everybody must know, okay. But then I've also covered Section 8. Section 8, everybody should know, not really must know. Section 8 deals with liability arising in contract. Okay, again, should know, not must know. It does depend on whether you're dealing as a consumer or not, okay. And then seller's liability, Section 11, should know, not must know again. It's interesting, though, that references there to sections 14 to 17 of the Sale of Goods Ordinance. SOGO is Sale of Goods Ordinance. And remember, the most important section there will be section 16, saying that if goods sold must be of merchantable quality and fit for purpose. Okay. And if those terms, which are implied into any sale of goods contract where the other party is a consumer, they are all conditions, okay? And so you cannot exclude liability for breach of sections 14 to 17 of SOGO if the other party is a consumer. However, liability for breach of sections 15 to 17 of SOGO may be excluded against others if reasonable. Again, should know, not must know. Similarly with section 12, okay? I mean, it's an important piece of legislation, everybody, but when you do your exam, it's closed book. So, I mean, are you supposed to memorize all of the CECO? No, you don't. I do, though, suggest that you know section 7. And of course, I think section 3 is very important, talks about the reasonableness test. So if you were to ask me, Mr. Greenwood, which parts of the CECO are must know, I would say section 3 and schedule 2, because that covers the reasonableness test. And then also section 7, which covers negligence. Remember, section 7 sub 1, section 7 is a good illustration in general terms of how the legislation works. If the CECO applies, it renders a contract either totally void, as in section 7 sub 1, or subject to the reasonableness test. So that's section 7 sub 2. So remember section 7 sub 1, talking about section 7. You cannot exempt liability for negligence causing death or personal injury. But you can exempt liability for negligence causing other damage, such as property damage, if it is reasonable. So what's on the screen, everybody? I would think must know. Section 7 is a very good illustration of how the legislation works. It renders an exemption clause either totally void, as in section 7 sub 1, or makes it subject to the test of reasonableness, section 7 sub 2. And with regard to the reasonableness test, I would suggest section 3 of the CECO plus the second schedule. But I would say they're the three must-know parts of the CECO. And you know what I mean by must-know when it comes to exam. So sections 3 and 7, CECO plus the second schedule. Get a grip on those parts of the CECO and you'll be in good shape for any examination question. Okay? All right, so where are we? Hang on, let me get my PowerPoint sorted out. Don't worry about sections 8, 11, 12. Okay, now, one case that I like to go through, even though it's not in your course manual, is on the screen because it raises some interesting issues. And it's the St. Albans District County District Council, I'm not sure what C means, and international computers. It's an interesting case, and as I say, it's more should know than must know. It dealt with a limitation clause in a business-to-business contract. And the reasonableness test applied because there was a clause in the, sorry, what happened was that the St. Albans District Council hired the International Computers Company to come up with some software for calculating a tax called the poll tax. And the poll tax, what's the poll tax? P-O-L-L. And the poll tax is a tax introduced by Margaret Thatcher in which the tax is calculated on the number of people in a flat, not how many flats you've got. So it's poll means head, so how many people were there. And in St. Albans, the council hired the International Computers Company to come up with some software for calculating the poll tax, but they got it wrong. And so the council sued the computer company for negligence. The issue was this, and there was a limitation clause, and the computer company said, okay, we're negligent, but there's a limitation clause which limits our liability to £100,000. So we said, well, that's a lot of money, yes, but I think the losses involved ran to the millions of pounds. So the issue in St. Albans, was that limitation clause reasonable or not? And the court applied our equivalent of section 3 and schedule 2. Remember, I think it's section 3 sub 4, which says the court, when it comes to limitation clauses, the court can take into account the resources of the defendant, including insurance. The other factor that the court looked at in the St. Albans case was that the parties had unequal bargaining power. Okay, so the court found that the limitation clause was not effective in the St. Albans case. The defendant was heavily insured, and the court found that the council could claim damages much greater than £100,000. It was in, I haven't actually got the figures, but the sum ran to some millions of pounds. So St. Albans dealt with a limitation clause and application of the reasonableness test. And the court found that the limitation clause was not reasonable. There was unequal bargaining power, and in particular, the defendant had large resources and also had access to insurance. Okay. So should know case, but I think interesting application of the legislation. Now, before we finish this exemption clauses, I thought I'd give you this particular PowerPoint because the Supply of Services Implied Terms Ordinance is also a piece of legislation in the area of consumer protection. Okay, so let's be clear, everybody. The main piece of legislation is the CECO. Good, well done. And with regard to the CECO, you know how it works. If it applies, it renders an exemption clause either totally void or subject to the test of reasonableness. And a good example, remember, is Section 7 of the CECO. And with regard to the reasonableness test, it's Section 3 and Schedule 2 of the CECO. Good. But, and this is should know, not must know, there is other legislation protecting you and me. So I hope you find this personally relevant. And it's the SOSITO, Supply of Services Implied Terms Ordinance. Now, I mean, this is not going to come up in the exam, although I suppose it could. If you get a question on implied terms in the exam, you could work in this particular piece of legislation because it's Supply of Services in brackets Implied Terms Ordinance. So, I mean, if you get somebody to fix your heater or whatever electrical apply, actually my toilet's broken down at the moment. So if I hire somebody to come and fix my toilet, then SOSITO will apply because he would be supplying services, not goods, he'll be buying services. Section 3 of the ordinance defines what a contract for supply of services is. Section 4 has a test similar to the CECO, defining who a consumer is. A consumer is somebody who's not in the course of a business dealing with somebody who is in the course of a business. And then sections 5, 6, and 7, interesting. There's an implied term to carry out the service with reasonable care and skill. So if somebody fixes my toilet and ends up breaking something, that could be in breach of Section 5. Section 6, an implied term to carry out the services within a reasonable time. Interesting. What is reasonable would depend on the facts of a particular case. Section 7, an implied term for the consumer to pay a reasonable charge. Good question. So if I get somebody to fix my toilet and he charges me $10,000, I'd say you're in breach of Section 7 of SOSITO. Okay, don't worry too much about Section 8. So SOSITO is an ordinance which was enacted in Hong Kong mainly through the efforts of Christine Low, who's a prominent local politician. It does follow fairly closely legislation in England, which again you don't need to worry about. Okay, but good piece of legislation. It's not a very big ordinance, so there you are. I challenge you to go and have a quick look at it because it's relevant to you and me. We are all consumers, and we may well get somebody to supply some services to us. Well, all of those sections on the screen apply. And by the way, all of those terms, the implied terms under sections 5, 6, and 7, they are all conditions. And you know what a condition is, remember? The more important term in the contract, breach of which gives the innocent party the right to terminate the contract and claim damages. Okay, good. So that's sort of a good, ties in nicely with what I was talking about at the beginning of our session today, talking about the classification of terms. Okay, so all of those terms implied under SOSITO are conditions. And by the way, all those terms implied under SOGO for goods, they are conditions as well. So important point to note. Okay, so if you do hire a contractor and he carries out his services in such a way as in breach of sections 5, 6, or 7, then you can terminate the contract and claim damages. Okay, good. Well, I hope to get somebody to come and fix the toilet in my spare room, and he better do a good job, or I will have, I will have an eye with regard to SOSITO. Okay, so that's everybody. We've covered exemption clauses pretty well today. Let's have a quick review of what exemption clauses is all about, so you're clear in your mind. Okay, so where are we? This is the key PowerPoint. This is the overview. Okay, so let's go through exemption clauses by way of summary from the very top. Number one, everybody, make sure you know the definition. What is an exemption clause? A term in a contract which seeks to exclude or restrict what? Liability or responsibility or risk for what? Either misrepresentation, which we'll get onto today, negligence or breach of contract. Okay. How do you know whether the exemption clause is effective as a defence to a claim for either misrep, negligence or breach? Well, to be effective as a defence, the exemption clause has to satisfy three tests: incorporation, construction, legislation. Okay, so they would be very good subheadings in any answer on exemption clauses. Incorporation, it won't be effective as an exemption clause unless the term is in the contract, in the body of the contract, either by signature, Lestrange and Grawcop, or by notice, Parker and Southeast Railways. Even if it's in the contract, it will not be effective unless the wording covers the legal wrong, and that's a matter of interpreting or construing the wording of the exemption clause, and the courts perhaps applying the contra offerentum rule if the wording is ambiguous or vague. However, the leading case here, everybody, is Ailsa Craig and Marvin Fishing. The courts now will not strain the meaning of the language. They will give the words their plain and natural meaning. Why? Because we have legislation, everybody, the CECO. And if the CECO applies, then it will render an exemption clause either totally void, as in section 7 sub 1, or make it subject to the reasonableness test, section 7 sub 2. And of course, the reasonableness test is section 3 and schedule 2 of the CECO. They're the must-know sections of the CECO. I'd say sections 3 and 7 and schedule 2. Focus on those and you'll be in pretty good shape for the exam. Of course, there's much more to the CECO, but as far as we're concerned on our course, it's just sections 3, 7 and schedule 2. Okay, I like section 5 though, the wolf in sheep's clothing. I always like that image. So if I see a lady walking around the streets with a nice woolly coat on, I say, aha, can you take your coat off, please? Is there an exemption clause underneath? Well, that might be a bit rude, but you get the drift. The suppliers did not like the legislation. They said, hang on, the law is now throwing up an extra hurdle, so let's see if we can avoid the legislation applying to us. So we will word our exemption clause in such a way that the CECO does not apply, but the legislators were onto that. So section 5 would catch these clauses that I call a wolf in sheep's clothing. They dressed up to look as if they're not an exemption clause, but in reality they are exemption clauses. Okay, good. So that's exemption clauses, everybody. Now we're going to get on to the next chapter, chapter 4, I think it is, in your book, dealing with vitiating elements. And what we'll be going to deal with, we're going to be dealing with misrepresentation to a large extent today. We may not totally finish it off, but we will certainly make a good stab at misrepresentation today. So just give me a second while I line up the PowerPoints. How quick can I do this? Let's see. Okay, not too bad. Okay. Adobe Connect, don't you just love it? Okay. I like the Adobe Connect system the way it is today. I've got used to it. And it's not too bad once I've done a lot of these classes. I'd say, I've done over 60 or so, I'd say 30 of them, 40 of them I can deal with, absolutely no help from anybody, but then there's always something perhaps goes wrong. I'm glad nobody's complaining about visual deficiencies or audio deficiencies today. Okay, and the chat box is open, so if you've got any comments or questions, feel free to drop me a line. Sorry, Mr. Pak-Ching, I can't really answer your questions, but with regard to the Parker case, remember, all you need to worry about is the ratio. Remember, Parker says, did the party relying on the exemption clause take reasonable steps to bring it to the attention of the other parties? Well, that depends on the facts of a particular case. All right, everybody, so now we're going to look at vitiating elements. You might say, what on earth does vitiate mean? Well, vitiate is a word that means it makes the contract bad, okay? Finding the party want to rely on it, must take, yeah, there you go. Got it. Well done, Mr. The last bit is, okay, wanting to rely on an exemption clause must take reasonable steps to bring it to customer's attention. Got it. Well done. Okay. It's good that some of you are taking the extra step of actually looking at some of the judgments in this case, but of course, some of the judgments are very long, and you say, well, I haven't got time to do that. But Mr. you're spot on. Well done. And it's a pretty old case, isn't it? Parker, 1877. I would say I like the Parker case because it lays down the general test. All the other cases like Ollie are interesting, but and also what's the case? Not Chapel, the one where the guys fell off the chair. I'll get that anyway. Oh my goodness! What is the name of the case where he fell off the chair? Oh, I should know that. Okay. Where is it? Chapelton and Barry. Okay. Chapelton. I like Chapelton and Barry because, I mean, when are you going to sit on a seat next? Well, if you're with somebody, hello, turn to the person. Hello, be careful with the seat, because if you fall down and get injured, you can sue for negligence, but there might be an exemption clause. Look at your receipt. I mean, we get receipts all the time, don't we? Do we really look at them? I normally look at my receipt, see how much money's left on my octopus card. Anyway, but sometimes if you go to dry cleaners, anybody? Have you look at their receipts. You find there's wording on the receipt for dry cleaners, which basically is an exemption clause. Okay. All right, so well done, Mr. Pak-Ching. Yes, you're quite right. You've got the test, and that's all you need to know. Okay, so let's get on to vitiating elements, and there are several vitiating elements, and I will tell you the must-know bits here. So we're going to cover misrepresentation first, and misrepresentation is must-know, and there's going to be a definition. It will be your number 5 definition. Okay, so aren't you glad you tuned in today, because you've got 2 must-know definitions. The first one, of course, is exemption clauses. Hey, hang on. Can you maximize the PowerPoint window? Oh, I could do it a little bit. Then I won't know who's attending. Okay, is that better? Okay. Oh my goodness, that's big. Okay, but I need to leave room for the. Yeah, I need to leave room. Hello, is that good? Can you? But of course, everybody should have hard copies of all these PowerPoints. So anyway, and I like blue. Isn't blue a lovely colour? So we're going to cover misrep today. Cover it pretty well today. Mistake is should know, not must know. Duress and undue influence, must know. Unconscionability, must know. Illegality is might like to know. You notice I've actually put it in square brackets, which is interesting because your course manual devotes about 20 pages to illegality. Totally unjustified in my humble view. Okay, I'm going to cover illegality very, very quickly. So let's go through it. Misrep, duress, undue influence, unconscionability are all must know. Mistake, should know. You're not going to be examined on mistake. Should know mistake, although there are a couple of interesting cases. And Illegality, forget. Illegalities might like to know. Okay, but our vitiating element for today is going to be misrepresentation. And first of all, let's look at the definition. There you are. What is misrepresentation? A false, as opposed to true, statement of fact made by a party to a contract which induces the representee to enter into a contract with the representor. Who is the representor? The person who makes the representation. Who is the representee? The person who receives the representation. And I'm not sure where I might have mentioned this before. There are a lot of O-R-E-E words, right? For example, donor, donee, tutor, tutee, employer, employee, okay, mortgagor, mortgagee, okay, so quite, well, not so useful, I mean, something to think about a little bit. Okay, the important issues with regard to the definition of misrepresentation I've underlined on the screen. What's the difference between a statement of fact and a statement of opinion? Good question, we'll look at that in a moment. And also, what do you mean by induce? Well, D-U-C-E is a Latin word meaning lead, so induce means lead into. And lots of D-U-C-E words. For example, produce, induce leads into, reduce leads down, and normally I do a sexy dance, seduce. She seduced him away from his girlfriend. So seduce means lead away from. So lots of D-U-C-E words. D-U-C is Latin for lead. So with regard to misrep, the false statement of fact must lead the representee to enter into a contract with the representor. Okay? So whether or not there is misrepresentation, apply the definition, and it's really a question of the common law, case law. So we'll be looking at some must-know cases in a moment. Important to note that the burden of proving misrepresentation is on the representee, and that's an important point to make. But the courts are usually pretty lenient as we'll see from the cases. All right. And if misrepresentation succeeds, it renders a contract voidable at the option of the misrepresentee, as opposed to void, okay? So make sure you know the difference between when a contract is made void and when it's made voidable. And if the contract is rendered voidable, it carries on until the innocent party takes action to terminate the contract, okay? So the innocent party has a choice. They have an option, okay? And if you don't do anything, the contract will carry on. So the representee has to take some action, otherwise the contract will carry on. Okay, and we'll look at the remedies for misrep in a moment. Okay, so let's go backwards a little bit. Misrepresentation renders a contract voidable at the option of the innocent party. You will notice duress and undue influence also render a contract voidable at the option of the innocent party. Okay, so must know, mistake exceptionally renders a contract void automatically. So that's rather drastic, isn't it? So a mistake is, pretty drastic remedy or result if an operative mistake is found. With regard to unconscionability, the remedies for unconscionability vary quite a lot, and there is indeed legislation, the Unconscionable Contracts Ordinance. And so we'll be looking at that, not today, probably next time. And under the UCO, it's really up to the court. The court has a wide range of remedies they can apply depending on the facts of a particular case. Okay, illegality, as I say, I'm going to cover that very briefly because it's might like to know. And the remedies or the effects of illegality do vary enormously depending on the circumstances. But make sure you know what that term voidable means. The contract carries on, but the innocent party has a choice. They can terminate the contract And until they do take action to terminate the contract will carry on. So the innocent party can't sit back and do nothing. They've got to take positive action to terminate the contract. Okay, and normally you do that by suing the other party. All right, so there you are. That's what misrepresentation is, everybody. Must know the definition. Must know, must know. Yeah, UCO, unconscionable contracts ordinance. Very long word, isn't it? Unconscionable. Is there a definition of unconscionable? The answer is no, there isn't. It's simply the court will look at certain factors, which we'll look at later, not today. Now today, everybody, we're going to be focusing mainly on misrepresentation. Make sure you know the definition of misrepresentation. Write it down, put it in your toolkits, together with the other 4 must-know definitions: offer, acceptance, consideration, exemption clause, misrepresentation. There's only one more must-know definition, and that's going to be frustration. We'll get to that when we get to termination of a contract. And I remember, in everybody, these definitions are must-know. They are tools to help you identify issues and exam questions. They are absolutely fundamental to the course. All right, they require a bit of memory work, but it's not too bad. But make sure not just that you're able to parrot off the definitions, make sure you understand them and be able to apply them. Okay, so there you are. That's the definition of misrep. Important to note that the burden of proof is on the representee, so that's an important point to make. And if there is misrepresentation, it renders a contract voidable, not void, voidable at the option of the misrepresentee. Okay, everybody, I think it's time for our second break, so we'll have another 10-minute break. After the break, we'll carry on then with misrepresentation. Okay, welcome back everybody. Hope you had a good little break there. So we're into the final stretch now, and we'll keep going till I collapse. No, okay, so I don't know, 5:15, 5:20 roughly will be when we finish today. Okay, so before the break, talking about misrepresentation. Normally when I'm in class, I do get somebody to actually say out loud what the definition of misrepresentation is and the other definitions. And of course, I always choose a lady for misrepresentation. Okay, I'm not sure. I mean, most students are okay with that. I mean, I know I've got a lovely voice, but I have to listen to other people as a bit of variety. And of course, a lot of people have much nicer voices than I have. So, and of course, the person who is saying what the definitions are, they will, of course, remember it. But of course, we all should know the definitions because they are must know. So what is misrepresentation? A false statement of fact made by a party to a contract which induces the representee to enter into a contract with the representor. Must know, must know. The burden of proof is on the representee. Important point to make, okay? And if it can prove misrepresentation, it renders the contract voidable at the option of the misrepresentee. The big question then is going to be, well, what are the remedies for misrepresentation? Good question. We'll cover that soon. Two main remedies. One is called rescission. What is rescission? R-E-S-C-I-S-S-I-O-N. Rescission means you put the parties back into the position they were before entering into the contract. By the way, lots of words start with RE. RE means back, okay? So that's what rescission is. You put the parties back in the position they were before entering into the contract. But there are what we call bars to rescission. Sometimes it's not possible to put the parties back in the position they were before entering into the contract. And so you won't be able to get rescission. You will get alternatively the alternative remedy of damages. And there is legislation in this area, and of course it's the misrepresentation ordinance. So when it comes to the remedies for misrepresentation, you go to the legislation, the misrep ordinance. And usually under the misrep ordinance, even though rescission may be available, the courts usually make an order for damages. So the most common remedy for misrepresentation, everybody, will be damages. And so we'll look at that in a moment. Okay, so let's get on to the three different types of misrepresentation. Must know. Fraudulent misrepresentation means somebody makes a misrepresentation dishonestly, if you like, and fraudulent misrepresentation is also a tort. And when we're dealing with this area of misrepresentation, there is a clear overlap between contract law and tort law. So you'll notice the name of our subject is called obligations, because people think, well, hang on, there's not much difference between contract law and tort law. I'm a bit of the old school. I think contract law is quite different from tort law, but there is an argument for saying they do overlap in certain areas, so we'll lump them together. But of course, when I'm lecturing you, I deal with contract first, then I deal with tort law. But there is a clear overlap between contract law and tort law, especially in this area of misrepresentation. So if a misrepresentation is made, you can sue either in contract law or tort law, okay? As we'll see in a moment, it's always better to sue in contract law because that is bringing in the misrepresentation ordinance. Okay, no PowerPoints. My PowerPoints are showing. Okay, how come there are no PowerPoints showing? Anyway, I can see my PowerPoints quite clearly. All right. Okay, the second type of misrepresentation is negligent misrepresentation. And negligent misrepresentation is also the tort of negligence. Okay, fine. And then there is a third type of misrepresentation where the person making the representation is not at fault at all, and this is called an innocent misrep. Okay, so important point to note, at common law, what do you mean by common law? No legislation. You could get damages for the first two types of misrep, but not any damages at all for innocent misrep. Okay. However, this has changed, and under the legislation, the misrep ordinance, you can now get damages also for innocent misrep. Okay, all right. So moving on to the next one. So having looked at the different types of misrep, let's get on to misrepresentation itself generally. How do you know whether there is a misrepresentation? Well, remember what misrepresentation is: a false. So, in other words, it has to be untrue, and that depends on the facts of a particular case. So it's a false statement of fact, not a statement of opinion. What is the difference between a statement of fact and a statement of opinion? Well, it depends on the relative knowledge of the two parties. If the facts are equally known to the two parties, a statement by one will be treated as a statement of opinion. Opinion, yes. However, if one party has special knowledge or expertise and the other party doesn't in that particular area, a statement by the party with special knowledge or expertise will be treated as a statement of fact. You're the expert, so you should know what you're talking about. Okay, so two cases here, Bissett and Wilkinson, contrast Smith and Land & House. Bissett is not in your course manual for some reason, but let me give you the facts of Bissett. In Bissett and Wilkinson, there was a statement made by a party about how many sheep a particular piece of land could support. So it's a New Zealand case. And nobody knew, because this particular piece of land had not been used before. So a statement about the carrying capacity of the land was treated as a statement of opinion, not a statement of fact, therefore not misrepresentation. By contrast, Smith and Land & House, which is on page 97, there was a plaintiff who wished to sell a hotel and described it as let to a most desirable tenant. Was that statement, most desirable tenant, was that a statement of fact or opinion? Well, the court said it was a statement of fact. Why? Because the existing landlord knew the tenant. The new party who was buying the property did not know the sitting tenant at all. And so the existing owner had special knowledge, and when he said that the tenant was a most desirable tenant, the court held that to be a statement of fact. Okay? So there you are, that's the test. You look at who the parties, and you look at the relative state of knowledge and expertise in that particular area. If they are equally expert or have equal knowledge of the facts, then that will be treated as a statement of opinion. However, if one party has special knowledge or expertise in a particular area and the other party doesn't, the statement by the first party will be treated as a statement of fact. You're the expert, so you should know what you're talking about. Okay, a little bit slightly tricky point, but should know, bordering on must know, is a silence. Is that a misrepresentation? Good question. These cases are on page 99. There are three possibilities here where the misrepresentor is not telling the whole truth. You're only telling half of the truth. Dimmitt and Halleck, the statement was held that flats were fully let, but the statement maker knew that some tenants had served notice to quit. The court found that that was a misrepresentation because you're not telling the whole truth. With and O'Flanagan is an important case because in With and O'Flanagan a statement was made which at that time was true, but by the time the contract was entered into, circumstances had changed which made the original statement untrue. In which case, if you keep quiet and don't say anything, then that will be a misrepresentation. So the Court of Appeal in With and O'Flanagan held that the failure to notify the purchaser of the change of circumstances amounted to a misrepresentation. And then the third type, more should know than must know. There are certain types of contracts, such as insurance contracts, in which there is what we call uberami fide, a duty to disclaim virtually anything that you might know, even though it may not be directly relevant to the situation. So in Lambert case, a woman renewed an insurance policy for her jewellery. The jewellery was later stolen. When she tried to claim for compensation, the company found that prior to her renewal of the insurance, her husband was convicted of conspiracy to steal. Well, I mean, how relevant is that? Good question. But the court held that the woman should have disclosed this information about her husband's conviction at the time of the renewal of the insurance policy. The failure to disclose entitled the insurance company not to pay a compensation. Okay, so the obligation is to disclose all information that is considered material by a reasonable insurer. Sounds a bit tough, doesn't it? But that's like, normally silence is not a misrepresentation unless the person making the statement is not telling the whole truth, or where there is a change of circumstances to make the original statement untrue. If you keep quiet then that would be a misrepresentation. I'd say should know, not really must know. Okay. Now, what about the next element? Remember what misrepresentation is: false statement of fact made by a party to a contract, which induces the representee to enter into a contract with the representor. Two cases, well, I'd say really, two cases. Redgrave and Hurd and Edgington Fitzmaurice. They are probably the two must-know cases. Redgrave and Hurd, slightly curious case though, in which the court says that the representee is not obliged to check the accuracy of a statement made by the representor, okay? Which is interesting because in Redgrave and Hurd, it was the sale of a business. I think it was a solicitor's practice, and Redgrave and Hurd is on Redgrave and Hurd. Got it. Okay. No, but it was the sale of a solicitor's practice, and the person selling the business said, it's worth a certain amount of money, let's say £50,000, but here are my books of account, you can check my numbers if you like. And the other party said, oh, no. And the court said, no, you're not obliged to check the accuracy of the statement. It seems a bit silly. If you got a chance to check it, why shouldn't you? That's what I'm saying. Is not the representee being negligent if he doesn't check it? But the court said no obligation on the representee to check the accuracy of a statement made. Okay, but Redgrave and Hurd, slightly curious case, but that's it. Other cases, though, the court found that the representee was not induced. Atwood and Small, for example. In Atwood and Small, it was the purchase of a mine. The representee did actually get his own expert to check this out about the value of the mine, and the court found that he was not induced because, by contrast, Horsfall and Thomas, plaintiff sold a gun to the defendant that exploded during test firing. Ouch. The plaintiff had concealed a defect in the gun by inserting a plug. The defendant refused to honour payment for the gun and said that this was a misrepresentation, equivalent to a statement that the gun was in a reasonable condition. The court held that the concealment may amount to a misrepresentation, but since the defendant did not inspect the gun and was not aware of it, the defendant was not induced by the concealment. So they're interesting cases, Atwood and Small and Horsfall and Thomas. But probably the most useful case, and I would say the must-know case, is Edgington and Fitzmaurice, which says that the reason for entering into the contract, the statement made need only be one reason for entering into the contract. So this makes it easier for the representee to prove a misrepresentation. Okay, so that's Edgington and Fitzmaurice. The statement need only be one reason for entering into the contract. So Edgington's on page 101. The plaintiff was not only influenced by the prospectus of the defendant company, but also by his mistaken belief that he had a charge on the assets of the company. It doesn't matter, as long as the statement was one reason for entering into the contract, that's still a misrepresentation. Must Supreme should know case, I think. God said whether it was reasonable for the innocent party to have been induced into the contract is not the crux of the matter, as long as the party was in fact induced. Okay. So I'd say the must-know case is Edgington Fitzmaurice, because that makes it a bit easier to prove misrepresentation. The statement need only be one reason for entering into the contract. Watch out for Redgrave and Heard, though, in that the court there said that the representee is not obliged to check the accuracy of a statement made. Okay, but you think a sensible person would check the statement if it's possible to check it. Okay, by the way, if you get an exam question here, if there's a problem type question, always be prepared to use your magic two-letter word, if the representee was induced. Okay, all right, so then moving on to the remedies for misrepresentation. So what we've covered, everybody, so far is there a misrepresentation? What is a misrepresentation? A false statement of fact made by a party to a contract which induces the representee to enter into contract with the representor. Okay, and the burden of proof is on the representee. Good. And if you can prove misrepresentation, it renders a contract voidable at the option of the innocent party, the misrepresentee. Now, if you are alleging misrep, you've got to prove there has been a misrepresentation. You also have to, everybody, state what type of misrep you are claiming. This is important. You can't just say that there is a misrep. You also have to say what type you are claiming. Is it fraudulent? Is it negligent? Or is it innocent misrep? Okay? So what type of misrep would you advise your client to claim? Okay, well, that's the issue here. And of course, with regard to remedies, as I've already mentioned, there are two possible remedies, rescission or damages. Okay, rescission is possible, but rescission, as I mentioned before, is subject to bars such as undue delay. Because rescission, the court's trying to put the parties back in the position they were before entering into the contract. But if there's undue delay, as in Leaf and International Galleries, and Leaf and International Galleries is someone on page 103, then of course, if it's a delay amounting to a number of years, then you can't put the parties back into their original position. Also, you can't have it both ways. You can't say there's a misrepresentation and then go ahead and affirm the contract as if the contract's carrying on. That's Long and Lloyd. Also, it may well be that it's impossible to put the parties back in the position they were because the subject matter of the contract has been passed on to a third party, such as in Lewis and Avery. Okay, so theoretically, you can claim rescission as a remedy for misrepresentation, but because of the bars to rescission, it's often not possible for the court to award rescission. Instead, they will award damages. Okay. Also, as we'll see when the legislation applies, that even if rescission is possible, the courts usually award damages anyway. Okay. So as I say, in theory, rescission is possible, but in practice, you get damages. Okay. Now, remember, if you're alleging misrepresentation, you've got to prove misrepresentation. You're the representee. You've got to prove all the elements of misrepresentation. You've got to prove it was a false statement. You've got to prove it's a false statement of fact. And you've also got to prove that you were induced to enter into a contract with the representor. You also have to state what type of misrepresentation you are claiming. Okay? And the type of misrepresentation you claim can be either fraudulent, negligent, or innocent. Okay. Now, if you are alleging fraudulent misrep, it's very difficult to prove. at common law because it's very difficult to prove somebody's dishonest. And there's a case called Berry and Peake on page 104, which illustrates that very well. Okay? You always advise your client to claim negligent misrep. Okay? Now, you could claim fraudulent misrep. Why would you aim to claim fraudulent misrep? Because the remedies, the damages awarded for fraudulent misrep are quite generous. You can claim all damages flowing directly from the misrepresentation, which is quite generous. If you claim negligent misrep at common law, the level of damages will be lower at common law because you will only be able to claim those damages which are reasonably foreseeable, and that's a much narrower measure of damages. Okay, so at common law, go for fraudulent misrep? Question mark? No, because it's very difficult to prove, even though the remedies are better. Go for negligent misrep. Well, at common law, you still have to prove negligence, but the level of damages is narrower. Okay, so why would you advise your client, the representee, to claim or allege negligent misrepresentation? Good question. The answer is because the law has changed, the law being the misrepresentation ordinance. The misrepresentation ordinance has made it much easier and much more generous to a negligent misrepresentee than at common law. Okay, so everybody be clear here. Make sure you know the difference between being at common law, in other words, case law, as opposed to legislation. Now, remember, with regard to the different types of misrepresentation, at common law, you could get damages for fraudulent misrep and negligent misrep, but not innocent misrep. However, this seemed very unsatisfactory because everybody thought, well, if it's an innocent misrep, you should still be able to claim damages. But at common law, you couldn't get damages. So it was thought necessary to introduce legislation to make it better for people claiming innocent misrepresentation. Also, it was thought necessary to make it easier for people claiming negligent misrep because it's still difficult to prove negligent. So the law has changed quite a lot with regard to remedies for misrepresentation. And this is why we have this very important PowerPoint. Okay? All right, so by the way, I presume you can all see the PowerPoints because one car man has asked that question. No PowerPoint. Well, the PowerPoints are there. I mean, I can see them clearly. So I presume you're seeing exactly what I'm seeing. All right. So, Mr. Wong, Miss Wong, I presume you can see the PowerPoint. Okay, so let's move on. Now, what's on the screen, everybody, is very, very important. I'd say 50% almost of all the marks on misrepresentation are on the screen. What are the other 50%? Well, the other 50% would be, well, what are the elements of misrepresentation? So remember, the representee has to prove misrepresentation. So you've got to prove those elements of misrepresentation. You've got to prove that the statement is false, number one. Number two, you've got to prove it's a statement of fact, not opinion. And you've got to prove that you have been induced. Good. And then you also have to state what type of misrepresentation you are claiming. Are you claiming fraudulent, negligent, or innocent misrepresentation? Well, because of the misrepresentation ordinance, you always go for negligent misrepresentation. Why is that? And the answer is on the screen, okay? And the answer, there are three reasons, if you like. The first reason why you advise your client to claim negligent misrepresentation is that under Section 3, Sub 1 of the Misrep Ordinance, the burden of proof is reversed and put on the representor. What does that mean? It means that the representor has to prove he's not negligent. Okay, so let's be clear. The representee still has to prove that a misrepresentation has been made. Good. Once you can prove a misrepresentation has been made, Section 3 says that reverses the burden of proof so that the representor has to prove he's not negligent. And this comes from the wording of Section 3, sub 1, which is the top of page 107, everybody. Get out your pens. Circle those two words, he proves. Okay, so top of page 97, third line down, circle the words, he proves. And in the context of Section 3, he is the representor. Okay, so that's the first point to make. So Section 3, sub 1 has made it much more generous towards a negligent misrepresentee. The burden of proof is reversed so that the representor has to prove he's not negligent. Okay, and that can be quite difficult. Secondly, the Court of Appeal in the Howard, Marine and Ogden case has shown that it's a heavy burden of proof. Why is that? Well, in Howard, Marine and Ogden, a statement was made about the carrying capacity of a ship. It turned out that that statement was false. But the representor said, I am not negligent because I relied on the Lloyd's Register of Shipping. So even though I made a mistake, I'm not negligent because Lloyd's Register of Shipping is regarded as the Bible in this area. Turns out that it was an incorrect statement about the carrying capacity of a ship because circumstances had changed and made that statement untrue. But the court said that even though you relied on the Lloyd's Register of Shipping, you were still negligent. So it shows it's a very heavy burden of proof. And here's the really controversial point. The level of damages for negligent misrepresentation is the same as for fraudulent misrepresentation. Now, this seems incredible, but it's based on two words, so liable. So liable, second line down on page 107, that person shall be so liable, notwithstanding that the misrepresentation was not made fraudulently. So you interpret the wording of Section 3.1 here by saying that the level of damages for negligent misrep is the same as for fraudulent misrep. Now, this is very controversial. It has been called the fiction of fraud. And everybody criticizes this because they're saying you are treating somebody who's merely negligent as if they're dishonest. Well, I put it to you, everybody. I mean, we do something every day which is a little bit negligent, a little bit careless. Fine, we'll admit that. But if somebody were to say you're dishonest, well, that's much more serious, isn't it? But this is what the law is doing here. They're treating somebody who is merely negligent as if they're dishonest. So this is very controversial, but it flows from first of all, the Hong Kong case of Pepsi Cola, and also confirmed by the Court of Appeal in Roy Scott and Rogerson. The Hong Kong Court of Appeal actually got in first on this, and Mr. Justice Cons in the Pepsi Cola case said, well, look at the wording of the Section 3 sub 1, and it does say you will be so liable as if you were fraudulent, so that's it. So everybody thinks that Section 3 sub 1 has been badly drafted, but that's the law, and that's what has been laid down. Okay. In England, they are making steps to amend the law because England has identical wording to Section 3 sub 1. But at the moment, Section 3 sub 1 is the law in Hong Kong, and so this so-called fiction of fraud survives. You are treating somebody as being fraudulent or dishonest when they are merely negligent. Okay, so watch out for this because in any question on misrepresentation, there are two big issues. Number one, is there misrepresentation? Well, apply your definition. Is it a false statement of fact made by a party to a contract which induces the representee to enter into a contract with the representor? Okay, remember the representee has to prove that. If you can prove that, then the representee also has to state what type of misrep he is claiming. And you always advise your client to claim negligent misrep. Why? Number one, because the burden of proof under the legislation is reversed and put on the representor. Okay? As a result of those two words, he proves in section 3 sub 1. And it's a very heavy burden of proof, as shown by the Court of Appeal decision in Howard, Marine and Ogden. Okay? And then finally, and most controversially, the level of damages for negligent misrep is the same as for fraudulent misrep. And that's a result of the Hong Kong Court of Appeal decision in Pepsi Cola and the English Court of Appeal decision in Roy Scott and Rogerson, in which the court interpreted the wording of section 3 sub 1 of the misrep ordinance so liable as meaning that. Okay, so the big query we have here is, all right, before the legislation, the remedies for negligent misrep weren't that generous. And also, the representee at common law had to prove negligence, and also, even if they could prove it, the level of damages was much narrower than for fraudulent misrep. After the legislation, the law has changed dramatically and swung very much the other way. And so the criticism is, now isn't the law under the misrepresentation ordinance far too generous to somebody claiming negligent misrepresentation? And most people agree it probably is now too generous. Okay, so watch out for that. That's very controversial. Now, just to finish it off now, we need to have a look at the situation. What happens if the the representor is able to prove he's not negligent? Well, then he'll be an innocent misrepresentor. Okay, and therefore, this will only be an innocent misrepresentation. Can the innocent misrepresentee get any remedy then? Remember, at common law, an innocent misrepresentee got nothing. But under section 3 sub 2, the court can award damages for innocent misrepresentation, albeit on a lower scale, in place of rescission. Okay, so that's good. So the misrepresentation ordinance has made a claim for negligent misrep much, much more generous, and also has made it possible for an innocent misrepresentee to get some damages, albeit on a lower scale in place of rescission. Okay. There's also a technical argument, which I'll mention briefly, perhaps we'll follow up next time. There is an argument, though, if you look at the wording of section 3 sub 2, what happens if rescission is barred? Can the innocent misrepresentee still get damages? Some cases say yes, some cases say no. Thomas Witter says, yes, you can still get damages, because the whole point of the legislation is to give a remedy to an innocent misrepresentee. But the other cases, Floods of Queensbury and British Aerospace, say no because of the wording of the section 3 sub 2. So this is a controversial area. Okay. All right. So let's sort of quickly wrap up misrepresentation. If you get a question on misrepresentation in the exam, 50% of your marks will be on the definition of misrepresentation. Is there a misrepresentation? Is it a false statement of fact made by a party to a contract which induces the representee to enter into a contract with the representor? Okay, good. But remember, the representee also has to prove the representation, but also has to state what type of misrep he is claiming. 40% of your marks will go for advising your client to claim negligent misrepresentation, that one. The other 10% will go to saying, well, in the situation, if the representor is able to prove he's not negligent, that means it will be an innocent misrepresentation. Then the innocent misrepresentee can possibly get some damages under section 3 sub 2. Okay, good. So that's misrepresentation, everybody, and we'll review this again when we meet again next week, which I think is Thursday next week, So we've covered quite a bit today. Don't forget your 2 must-know definitions, exemption clause and misrepresentation. So what we'll be covering next week will be the other vitiating elements. We will be covering mistake very quickly because it's more should know than must know. But also we'll be dealing with duress, economic duress, which we have actually covered already with Williams and Roffey under the heading of consideration. And also then we'll be covering undue influence. What's undue influence? It's the equitable counterpart of duress, and then also unconscionability. So we'll be spending pretty well all the time on the rest of chapter 3 next time we meet. So if you want to read ahead. Okay, everybody, I think that's pretty good for today. We'll wind it up there, and we shall meet again next, I think it's Thursday next week, isn't it? 21st, I think it's 21st of January. So everybody have a good weekend. Stay warm, although the weather's not too bad today. And we'll follow up with this next Thursday. Okay, thank you. Thank you for your attention. And I hope we can meet in person before too long. Okay, hang on. Thank you. All right. Okay, so I presume everybody can see the PowerPoints. I don't know what happened to one car man, but everybody else seems okay. Thank you very much. And good feedback. Teaching. Somebody say that teaching is my medicine. Oh my goodness. Okay. And read ahead if you can. And don't forget these must-know definitions. They are critical. Okay, thank you. That's it for today. And I'll see you all next Thursday.